All right, friends, we're back at it again with the RF101, which in Tennessee, this is the exclusive right to sell listing agreement, and this is going to be for designated agency. And so what that means is that the seller and the listing firm are going to be in partnership together to get the property sold, and the listing broker has appointed a designated agent in the office. And so the designated agent would be likely the agent that is hired for the job, and they're going to be the only agent representing the seller with the exclusion of all the other agents in the firm. And so when then the same firm brings the buyer, they would be the designated agent for the buyer, and you'd have the designated agent for the seller, and it would not be considered a dual agency because each agent represents each side independently. All right, so let's walk through what's going to happen here on this listing agreement. The first part of it is really just who's representing who. So the firm that's representing the seller, and then who is the seller/owner. This would include their full legal name and the address as to where the seller actually lives. Sometimes that address is different than the actual property being sold. And so down below would be the address of where the property is being sold. And on my previous video, I kind of walked through what the instrument number was. So if you missed that, check out the RF401 video. But the instrument number is found on the deed, and it's like a special number that it gets recorded with the county as to where the property is registered. And so you can utilize the deed book and page numbers and or the instrument number here. It's just a special number that is tied to the property, and it helps identify the property a little bit better than just the property address, because sometimes the address can change from the post office. And so the instrument number actually records to the specific deed that this property is sold and recorded under. So let's go ahead and talk about all the things that stay with the property. We call these things that convey. Everything you see here in paragraph A stays with the property automatically. Everything down to the curtains and their rods. All right, you're like, Kayla, that sounds crazy. Nope, they all stay. So if you want to take your window treatments, you need to make sure that the listing agent is identifying that, and that when you're negotiating a purchase and sale agreement, that those things stay on the purchase and sale agreement as items that do not convey. Otherwise, they automatically have to stay with the house. Now, there's some other things in here that often come up as items that get lost in translation. So I'm just going to point those few things out. The biggest one is going to be the EV mounting brackets. Okay, I'm not talking about the TV gets to stay, but the bracket that holds the TV to the wall, all of that has to stay with the property. And so if you intend on taking your TV mounting bracket, you need to let the listing agent know. And so when this happens and you get your house packed up, if you have somebody packing you, especially if you're doing like a military move, which is very common in my marketplace up here at Fort Campbell, you need to make sure that the moving company takes the brackets that are attached to the TV off of the TV and then hook them back to the plate that gets mounted on the wall, because that whole system needs to stay together. Another item that comes up is going to be the pool equipment. So if you have a swimming pool at your house, just know that all of the equipment that operates the pool needs to also stay. We see this happen more so on the above ground pools, where people start taking all the equipment. It's like the skimmer, the robot, the pump. They start detaching everything for whatever the reason. Those things all need to stay with the property. It goes for the same for in-ground, but we often see it more occur with the above ground, where things start getting taken off. Okay, you also are going to see some things in here about appliances. Now, all built-in kitchen appliances remain with the property. Now, notice I said all built-in kitchen appliances. So if you have a mini bar or something like that somewhere in the house, and you have an appliance like a little mini fridge with it, those need to be identified as items that get to stay with the property at no additional cost to the buyer, or it needs to be known ahead of time if it's going to be negotiated as an item that is going to be negotiated with the price, or the buyer is going to have to pay for them outside of the sale on what we call a separate bill of sale. The range is listed on line 19, and so therefore on section B, it does not need to be identified. Sometimes agents go in here and they start repeating things that are already in paragraph A. Just know that if it's in paragraph A, they automatically stay. They don't have to be repeated in section B. Section B are things that are additional that can stay at no additional cost. All right, things that we often see in B are going to be things like a refrigerator that is not affixed to the cabinet. So those are the refrigerators that slide in and out of a nook space. And or we see mini fridges and wine coolers. Those also in the kitchen often slide in and out. And sometimes the washer and dryer. Okay? Anything else like playgrounds, trampolines, I've seen sheds, all of that stuff often cannot be here. Now, a shed might be allowed by the lender, and so you want to check with your lender partners if they'll allow that here. The reason for the shed is because the shed often is given value to the property on the appraisal. So check with them about the shed because every company is different and what the underwriters allow and don't allow changes all the time. But for sure, those trampolines and those kids' play sets, all those things are personal property. Lawnmowers I've seen where they're asking for the gym equipment here. Like all that stuff needs to go on a separate bill of sale outside of this real property purchase. Those are personal property. We're talking about real property, which is real estate. Okay, things that are not going to stay with the property go under C. So if the seller has identified or you are the seller and you've identified, you're going to take that special chandelier. Maybe it's a family heirloom and you don't want it sold with the property. If it is there during the time of the pictures or the showings, you need to make sure that the agent identifies it's not going to stay on the purchase and sale. Okay, last item here is the leased items. Leased items that are often common are going to be security systems, water softeners, propane tanks, and there might be some others that you'll have where there is a payment that's happening monthly. Okay, seriously, get out. You guys are seriously making it so difficult. Go and get out. Never going to get these videos done. I've literally recorded it 12 times. 9. Okay, so now we're going to talk about the leased items. Leased items are things like a security system, water softeners, propanes, anything that you're making a monthly payment on and you have a contract for. Oftentimes we have this confusion of the Ring doorbell system being a leased item or not. The Ring doorbell system, you have a subscription to. It's not a lease. Things more like ADT or Vivint, those kind of programs where you've signed a contract and you're in that contract for oftentimes, sometimes up to 5 years. Those are leased items. There's an agreement that you sign that says you're going to keep the system and you're going to make the payments for an extended period of time. So if you have something like that on a listing, you need to make sure that it's identified here because the buyer has to make the decision. Do I want to keep the lease or not keep the lease? Because if they keep the lease, they then have to pay a transfer fee in most cases. But if they decide not to keep the lease, the seller's on the hook to pay off any balance items that are left behind. So if you have a security system and say the balance on it says that you owe another $2,000, you have to pay off the balance, okay? Or you remove those items and you have to put the home in its back current order. So sometimes water softener systems are a little bit harder because they're all tied into the plumbing. So you would then pay off the balance as a seller and the water softener system gets to stay with the buyer. All right, moving on is going to be the listing price. This is the price that the listing agent and the seller have discussed and negotiated and determined is going to be the price for the property to be initially marketed. The listing agent does provide a market analysis to let the seller know, hey, this is the range of value that the house is going to be likely the most competitive at, and therefore the seller then gets to decide where the listing price is going to be. Now this agreement is effective the day it's signed. Doesn't mean that house has to go on the property on that day. It just means that the agreement between the firm and the seller are now in effect under legal obligation through the expiration date. Now, the property can begin marketing in the future. So say you sign today and you want to list it next Friday because you've got some honeydew things you need to get done, the photographer needs to come. So that date would then go down below, and we call that coming soon. And now coming soon could be advertised or not advertised. There's 2 different ways to do it in RealTracks, which is what we utilize here in Middle Tennessee. But across Tennessee, if you're watching this video, There's many different MLS systems. And so you want to check with your MLS to see what your rules are on the coming soon, and or once you've signed an effective listing agreement, how many hours or how many days do you have to place the property on the MLS, whether it's inactive or coming soon or actually active. Every MLS has a different rule, so make sure you check your MLS rules. Now, the next paragraph is going to talk about the carryover clause. I'm going to pause here because the carryover clause means that from the effective date to the listing expiration date, what happens if after the expiration, a buyer who saw the property during that period comes back and wants to offer on the home? It happens. The listing agent will place a number of days after the listing expiration here on line 47. So say it's 30 days. If a buyer who saw the property from the effective date to the list expiration date comes back within 30 days and the property has not been relisted by another agent, this carryover clause states that the listing agent will still be compensated based upon whatever is set forth in the agreement. Okay, so if the buyer saw the property during the listing period and then the listing period expires and they come back within the carryover days right here on 47, the listing agent is still compensated. Now on 52, there is a line that says that the carryover clause shall not apply if the property is listed by another listed licensed real estate broker. And so say this agreement is set to expire and the seller says, you know, hey, I want to hire somebody else and I'm not going to rehire you. So they initiate the conversation with another broker. That's allowed. They're allowed to initiate the conversation with another broker, and the other broker can have discussion about a future listing agreement. Now, it could expire today and the next listing agreement could go active tomorrow. That's allowed. And so it gets a little confusing, and we often have agents who are saying, well, that's my buyer. Well, it's not your buyer. It states very simply here that carryover clause shall not apply if the property is listed with another licensed real estate broker. Now, the next section is the possession of the property. This is often going to be the date of deed, which means that when the buyer and the seller go to closing, they sign and there's money transferred. The seller gets compensated, the buyer gets the keys. That is the date of the deed. The deed gets recorded in the registrar's office of which the county of which the property is located. So it's all recorded, everything's done, that's date of deed. Now, sometimes the seller needs to stay post-occupancy, meaning they need to close and they have to stay in the house for a little bit, upwards of 30 days. I've seen 60 days. It just depends on their situation, especially if they're using the money from this house to move to the next house. And so if they're doing that, then at this point, you would have a date of deed 30 plus 30 days, meaning we're going to close. I'm going to stay in the house for this many days. And we're going to have an agreement when the offer goes through, and that agreement is a post-occupancy agreement. And that post-occupancy agreement is for up to 60 days, and the seller is going to pay a per diem to the buyer. And that form is going to be the RF627. Now, it could be negotiable, but I would be very specific here on the possession of the property. If you wanted to negotiate that, obviously that could be negotiated. All terms are negotiable between the buyer and the seller when the offer is given to the seller. But here, you really, as a listing agent, you want to be firm. Are you moving out and transferring the keys once you get paid? Or do you need to stay in this house afterwards for a number of days? And just let them know that the post-occupancy agreement that we have here in Tennessee is for up to 60 days. It's not a lease agreement. It's just a per diem. It's a temporary possession of the property. Now, the next one is going to be your terms of payment. How are we going to pay for those things? Well, if the property cannot accept government-backed loans like FHA, VA, USDA, obviously you would put here that the seller's only accepting conventional or cash. You could also have something here like owner financing. It just depends. Every seller is going to have a different situation with their home. And so therefore, you need to make sure that you're very specific here as an agent, what the terms are, so you can advertise what terms are acceptable to the seller. All right, this next section is new. Number 6 talks about seller concessions. It was added during the mid-year because there were sellers that were a little confused about what a concession is. They're like, I'm already paying the buyer broker. I'm already paying the listing broker. I'm already paying. So why am I being asked to pay for more stuff? Well, here we go. There's things called concessions. The buyer may ask for this stuff. And so when they ask for these things, it would be things like a home warranty or repairs or money that goes towards their closing expenses, in which the lender's called closing cost. Buyer broker compensation was modified on August 17th of 2024. There was a class action lawsuit that caused a large NAR settlement. A lot of the real estate companies had to also settle and pay billions of dollars in this lawsuit. And so now buyer broker compensation has changed. And so that's where we're going to get into this next section. And I'm going to go a little bit slower here because it's still a little confusing for some agents and for some consumers. So that's why I'm here. All right, the first one's going to be the first total compensation that's payable to the listing broker. So this is the total amount the seller will pay that will go on line 62. Okay, the seller pays the listing broker. Now, the listing broker and the seller could negotiate together to say, hey, I'm going to give you this total, whether it's a dollar amount or a percent of the purchase price, and I want you to give some of this total to the buyer broker. You can advertise it. You can tell them like what this amount is. And that amount goes on line 69. We call this cooperating compensation. Not all states do this, and most of the states remove the cooperating compensation here, and it's fully negotiable through the purchase and sale agreement. You can still do that, and that's totally fine. But if you're going to do that, then this total line section on 62 needs to be the amount that's payable to the listing broker only. And then the cooperating compensation would be 0. And then if you wanted to negotiate to pay the buyer broker as a concession, like we just talked about the seller concessions in the paragraph above, then at that point you can negotiate it as a concession through the stipulations of the offer. So you have 2 ways to utilize section 7, which are the 2 paragraphs that start on 62 and 69. Those 2 lines can work either way right now. Now, it could change as things evolve, but just know that 62 is total. The 2 numbers merge together if you're offering buyer broker compensation and listing broker compensation together. And then of the total, like on line 71 in bold states, of the total, how much is going to be given to the buyer broker for cooperating. Okay, another word that they changed here in 2025 at the beginning of the year was the word percent, now reads as amount. And I've got those 2 words highlighted. So there was a mid-year change and then it shifted again in January to change everything from percent to amount because it could be $1. Okay, so if we've initiated this cooperative compensation, meaning the listing broker is getting a total and they're going to give some of their total to the buyer broker, we're going to utilize this RF101, which is the cooperative compensation between the listing and the selling broker. Now, the selling broker, just for terms for the consumers watching this, a selling broker is also known as a buyer broker. They're the one helping the buyer. The listing side is helping the seller. So here's that compensation agreement between the listing and the selling broker. It simply states that, hey, I'm the listing agent and my seller has already agreed on this section here that we're going to offer you, the buyer broker, a dollar amount or a percent of the purchase price. It's a predetermined amount, and this will be signed by the 2 agents. And so if the cooperative compensation was 0, this form does not exist, and all of the compensation is negotiated as a stipulation of the offer. Now, this next section is for lease. If the property ends up leasing during the listing agreement, which often happens, we're seeing it more and more now, not so much the last 4 years, but we are definitely seeing it more now, where, there might be 2 signs in the yard, one for sale and one for lease. And if the property goes up for lease before it sells, great, sale side comes down. Well, when the sale sign comes down, what happens? Well, the broker could put here that the seller agrees to pay a total amount, a dollar amount, or a percent compensation based upon the monthly rental amount that is going to be paid. And that is going to be within 5 business days of when the rent is due. And so this one would be in lieu of a cancellation fee. So as a listing agent, you would go into the conversation with the seller and say, hey, I'm going to do my best to sell this property. You have elected to also cross-list it with property management. Maybe it's in the same company, maybe it's a different company, irregardless. Should the property lease before I can sell it, you owe my firm blank number of dollars or a percent of whatever the monthly rental rate's going to be. And that is due within 5 business days of the rent being due. And it's payable to the broker. Okay. Said compensation from the seller to the broker shall continue for the duration of the lease. This part, everybody skips. So for the duration of the lease, the listing agent still gets compensated a percent of the monthly rental or a dollar amount for the duration of the lease. Now, could you negotiate to not do that and only have a one-time? Sure. The best way to do that is through a cancellation, and that's this next paragraph. Okay, should the broker consent to releasing the listing prior to the expiration date, the seller agrees to pay all costs incurred by the broker, as well as potentially paying a cancellation fee. So you might incur as a seller all the costs, but in most cases, the agents are going to have what we call a cancellation fee outlined in their agreements. And so it just says that, hey, at any point in time, you determine that you no longer want to sell your house for whatever the reason, there's a cancellation fee of blank number of dollars. And that's going to be compensating the back for any of the marketing expenses that they've paid for and also their time, energy, and efforts. Okay, the next is going to be the responsibilities and the rights of the parties. Point blank, the broker can have the authority to advertise the listing. Okay, they're going to put it on the multiple listing service, which we call the MLS, and they're going to let other people know. The seller understands and agree that they're going to participate in the MLS, and the MLS also provides access to third-party sites. Now, there were some changes recently in the month of April where the National Association of Realtors changed clear cooperation rules, and so the seller does have the opportunity to do a delayed listing, and they also have the right to say, I don't want it on any third-party sites. So if that's you, you need to let the listing agent know ahead of time, and they should be asking you those questions at the consultation, just so you can make an informed decision. Now, this next section talks about the real estate sign and the lockbox being placed on the property. There's going to be some restrictions for some communities that does not allow a real estate sign to go in front of the property. And if it's a gated community, often they want the signs on the outside of the gated area. So it wouldn't actually be in front of the house, it'd be outside the gated area. But at some times, there might be a seller that says, hey, I don't want a sign in my yard. I don't want my nosy neighbors knowing that I've got my property sold or to be sold. And that's okay. They have that right. But as an agent, you would need to put that in the stipulation that the real estate sign at the request of the seller shall not be placed on the property. Now, in 106, this talks about providing the property disclosures to the seller. If you're an agent, these are going to be the 200 series of your forms library. And so the first one here, the residential property condition disclosures, the 201. The disclaimer is going to be the 204. Your exemptions, the 203. And then your property disclosure form is going to be the 205. And then it also mentions lead-based paint disclosure. That's going to be the RF101. So you have lots of different disclosure forms that need to be provided. And you also need to know that there might be some pictures taken inside, outside, plus video and audio. All right. The seller does give permission for all of those to happen. And if the seller does not want those to happen, it needs to be outlined in the stipulations block at the very end of this agreement that we'll cover. Okay, we're going to advertise the property on the internet. That's where you get the most exposure for all properties is on the internet. We're going to advertise as the broker deems appropriate. So some brokers do paid ads, some do not. Some host open houses, some don't. As a consumer, you need to be asking the listing agent, what services do you provide and what is something that I should expect from your advertising? And the agent should be able to provide you with information on what they do to advertise the property because they're all different. The seller shall allow the property to be shown at all reasonable hours. And so reasonable changes, those with small children who have to get off to school in the morning, they often, don't want an early start to showings because they're trying to get everybody out the door. We also have consumers that work the third shift. And so, maybe mornings aren't best for them because they're sleeping because they had to work the night shift. So everybody's different. And so you need to identify what the reasonable hours are as an agent to the consumer and the consumer to the agent. So that way the property can be ready and available, but also time blocked. So that way the buyers and the buyer's agents are not requesting to see the property outside of what the seller deems reasonable. We see this at nighttime too. A lot of people want to stop showings around 5, 6 o'clock so that way they can prepare dinner and be home, get everybody ready for bed. But there are some people who, maybe the house is vacant. They don't care. Or they don't have little ones that they're trying to put down for bed, or they don't have pets that they're trying to load up in the car. And it's easy for them to just say, hey, you can show the house up until 8 o'clock, especially in the summertime when the sun is up really late in the evening. Show this thing. We can just get in the car and go drive around the neighborhood. That's totally fine. So just make sure you discuss this during the listing consult of what is a reasonable hour, and then cooperate with the broker. If you were an owner and you have a tenant inside your property, know that the tenant needs to receive 24 hours notice for all showings and access to the property. And so that also needs to be set in the listing service and the showing centers, that there is a 24-hour hold, that the tenant needs to be given ample notice that somebody's coming. Okay, the rest of it just talks a lot about the Code of Ethics and Standard of Practice 1-5. And this is going to be very specific about how the broker shall follow the seller's lawful instructions of disclosure. Okay, as a consumer, if you tell your agent something and you want them to break the law, just know that they are not allowed to break the law, and they also are bound by the Code of Ethics Standard of Practice 1-15. Next up is going to be the Foreign Investment in Real Property Tax Act, which we call the FIRPTA disclosure. This is specifically for sellers, and they need to seek advice from their CPA or their tax consultant regarding any taxes that might be due at closing. Okay, this is for foreign investment. It's a real estate property tax that's for foreign investors. And also for non-US citizens. So if you feel like you fall in this category, you need to check with your tax advisor of, are you going to be responsible to pay this tax? And if so, you need to disclose that to the agent ahead of time so they can let the title company know, hey, we do have a FIRPTA that it needs to be disclosed. Next is going to be section 10. This one goes in hand with that one line that we just saw about the broker is going to give you the disclosures that you need to fill out. But the hold harmless and limitations section is here in 10. So it's the seller's responsibility to fill out those disclosures. It's not the agent's responsibility. In fact, in Tennessee, the agent cannot and will not fill out the residential property disclosures. Those are to be filled out by the consumer, and they're to disclose all known knowledge about the property. And the RF101 is for the existing homes with 4 doors or less. That's what we deem residential. And that disclosure is a couple pages. You'll fill out yes, no, I don't know questions, and then you'll sign, and then the buyer will review it prior to writing an offer, and then they will submit it with the offer that they have read and have knowledge of the information provided. Now, the property may be exempt, and there are 16 ways that the property is exempt, and so they will check off how and why they are exempt based off of one of those 16 items, and they will fill out the RF203. So if you haven't lived in the home within the last 3 years, you're exempt. If it's the first dwelling, meaning it's a new construction, it's exempt. There's many reasons that the property might be exempt, and so that will be disclosed, and they will fill out a 203. And so at that point, they have really no yes, no, I don't knows, except for just a few items, such as sinkholes and is it in a planned unit development, and a few other disclosures. Okay, let's keep going. The lead-based paint disclosure is the RF101, and this one is required by law for all properties built before 1978. So 1978 is the trigger mark for the lead-based paint disclosure. You will receive a pamphlet from the EPA as well as fill out a disclosure where the seller will sign saying, I have knowledge or I don't have knowledge of lead being in the home. And then the buyer will have the opportunity to say that they want to do lead sampling or they accept the property in its current condition and they waive the sampling test. That's all disclosed in writing. Up next after that is going to be this bottom section where we are going to start talking about adverse facts. And so adverse facts are listed here. There's a few different things that fall under adverse facts. That's going to be any defect, such as environmental factors, that are not disclosed by the seller. The broker then has to disclose them to the consumer. So if there's knowledge that there is a problem, that would be an adverse fact or an environmental hazard, and the seller has not disclosed, know that the agent is legally responsible to disclose this. And so my little bubble kind of covered up, so I'll move this up for you so you could see it really fast. But adverse facts in the Tennessee Code Annotate, which is in Title 62, Chapter 13, Section 102, and even further down in subsection 2, that's where you're going to find the definition of adverse facts. Okay, conditions or occurrences generally recognized by a competent licensee that have negative impact on the value of real estate, significantly reducing the structural integrity of improvements to the real property or present a significant health risk to the occupants. Okay, next up is going to be just a, hey, heads up. We live in a world where video surveillance is always happening. We've got those little Ring cameras all over. We also have creepy little teddy bears in kids' playrooms recording all the time. So just know there's going to be a potential video recording, and it is the seller's responsibility to check with state and federal law regarding the video and audio recording devices while marketing and showing your house. Okay, seek legal advice before you start recording everybody in your home. Next section is going to talk about how the seller authorizes the broker and or the broker's affiliated licensees to conduct showings or open houses. And so you might have a listing agent that represents the firm and they're representing this particular property. And agents from the exact same firm may be the agent sitting in the open house. Okay, that they may be the one that like they don't have listings, and so they've asked this agent like, hey, can I do open house in your property to help promote your property, but also for them to generate traction for the buyers to come through and hopefully represent the buyer, and that is allowable. Now, what is not allowed unless authorized by the brokers on both sides is where cross companies start doing open houses in other companies' open houses. So that has to be disclosed, and it also needs to be approved by the brokers. But otherwise, you might have your agent and any of the other agents in the office doing those open houses. Okay, the seller authorizes the broker to also be the key holder and have access to the property. That's where the key goes in the lockbox, and the lockbox then placed at your property, sometimes affixed to your door, and sometimes the agents have made cute little door hangers or signs that go next to your house. It all depends on the agent. Okay, the seller must maintain adequate insurance. I'm going to say it again. The seller must maintain adequate insurance. Okay, that's to protect the property from any damage or loss that might occur. In the RF401 video that I did previously, you can go check it out. There's a whole section regarding what happens if there is a loss that is 10% or greater of the purchase price, meaning the house catches on fire. There's a flood, which here in Tennessee, we just had weeks of, a couple weeks ago of flooding. So what happens if there's significant damage of 10% or greater, or potentially a whole loss? What happens? Well, hopefully the seller kept their insurance and hopefully the insurance will cover it all. But the buyer is not obligated to perform on the property and continue to closing if it's greater than 10% of the purchase price. So just know there is a need to keep your insurance through the entire process. There are sellers that will cancel their insurance. Okay, they cancel for whatever reason, and it's like, why are you canceling? Keep that thing going. You keep it going all the way to the day of closing, because the buyer hopefully will have their insurance started, and it needs to begin the day of closing too. So that way you've got complete crossover of the insurance policy. So should the property have some damage or anything to it, it's covered. All right, now it also has a section in here on line 163 that talks about entry to the property for the above key that was authorized. Okay, so you agree to hold the broker, its licensees, salespeople, and employees harmless of any loss, theft, or damage incurred during results of showings, open houses, or unauthorized entry. Okay, there's a hold harmless listed in here. This next section talks about what the seller acknowledges to do. So as a seller, you acknowledge and you allow the broker to show the property. Obviously, we want to get it sold. So broker and all the other buyer's agents can go and show the house. Okay. They understand that the broker is not an expert in all things. There's a whole paragraph of all the things that the agent's not an expert of. And so this is the just disclaimer. You often will also sign a disclaimer notice, which is the RF101 that has additional expanded version of this. But the agent is the agent. They're here just to sell the house. They're the marketing expert. They're the listing consult that is going to be your negotiator and assist you with pricing the property to get it moved in the shortest amount of time, but also for the amount of dollar that you're looking to seek. Okay. They're not a home inspector. They're not surveyors. We often are not, perfect at measuring. We're going to do the best, but square footage might be a little off. If we don't have a plat or a survey, we're going off of the acreage that you're telling us. We're going to double back and try to confirm it with the data that's available, but you hold us harmless from having that information being incorrect. So this 2 items just talk about the Tennessee Real Estate License Act of 1973, and also that we may make disclosures required by law and or the National Association of Realtors Code of Ethics. There's a whole bunch of things. There's 17 articles in the Code of Ethics, and then the law for real estate here in Tennessee all falls under Title 62, Chapter 13. So tons of rules, tons of laws, and then we have the commission in Tennessee, which is the Tennessee Real Estate Commission, that also has rules too. So next up is going to be expert assistance. This is just an expansion of the disclaimer that I just talked about, and there's that RF101 noted on the bottom for you. Most of the agents have a vendor list that they're going to provide to you for additional help with some items that you might have in your house, and that agent may also provide you an RF711. That's the vendor list. And so they might list their 10 vendors that they like to work with, and then you can, utilize those people or not utilize those people. They're just going to be giving you names. Okay? They're not going to certify that the workmanship is going to be, 150%, but they are typically vendors that have been vetted by other people, and they've done a good job before. Okay, the next one just talks about if the broker provides the names and or sources, that we don't warrant or guarantee the services and or the product. And you'll see that disclaimer listed on that RF711 as well. Now, there's going to be some types of agency here in Tennessee that we need to cover because every state is different. And as the pandemic happened, more and more people were moving from other states and coming here, and they're very confused of how we were doing agency because in Tennessee, we have different ways we can do agency. So let's talk about them. When we utilize the word broker, it means Tennessee real estate broker or brokerage. Okay, we have affiliate brokers, which is the beginning level license. So you have affiliate broker, and then you can have an upgrade to your license after 3 years and 120 continuing education hours. Then you pay to upgrade, and you also have to do another exam, and those are called brokers. So you can then be a broker. And then you'll have principal broker, and the principal broker of the office is the responsible for all brokers and affiliate brokers. So they're the tippy top. There's only one for every office, and they're responsible for everybody below them. A designated agent for the seller is where you'll have the principal broker, or in some cases, the managing broker, who will appoint the agent. And typically, it's the agent that you, the consumer, have hired. And so that agent is going to be the agent representing you exclusively, and that you're going to work with them and you're not going to cheat on them and go work with somebody else without having a cancellation first. Okay, the next one is called a facilitator or a transaction broker. That means that the agent is not an agent for either party. And so you might see what happens sometimes where you'll have a for sale by owner, and then you have somebody that's a buyer, and they kind of bring the two parties together, and they're the facilitator. They don't represent the buyer, they don't represent the seller. They facilitate this transaction. They do the paperwork, they pass the paperwork back and forth, but they don't represent each side, one or the other, exclusively. All right. You might have a situation where the listing agent signs a listing agreement with you, the consumer, and you are being represented as the listing by the listing agent. And then a buyer comes along and they might be unrepresented. And your agent may say, hey, I can change my status and I can be the facilitator to the transaction, and you will do a change in notification to both sides. That is allowable. However, some brokers do disclose to their agents that they just need to stay with the listing. You represent the seller, you already know what the bottom line is, and you know what the needs are. And so that, therefore, it would be really hard to help a buyer get what they want when you already know the bottom line for the seller. So it's best just to say the listing broker for the seller and keep the buyer unrepresented. So there's different ways to do agency. We do also have the option for dual agency here in Tennessee, which means that both parties are represented by the exact same agent, and that needs to be disclosed to both parties. Both parties need to agree in writing and they consent to it, and that is also filled out on an RF303. Okay. Otherwise, you're either the agent representing the seller or the agent representing the buyer. Sometimes you're just a facilitator, you're the paper passer, and sometimes you're the agent for both. It just depends. Now, you do have the option for adverse facts listed here. This is what we've already kind of disclosed on the previous slide, where we're negative impacting the value of real estate, reducing the structural integrity, and presenting a health risk. If the seller doesn't disclose it, the agent must disclose it. But number 6 talks about confidentiality. Everything else needs to be held in confidence. Okay, this is the responsibility of the agent to not disclose everything to a buyer broker or the buyer themselves when they're representing the seller. They need to keep it zipped tight. Okay, there is a section on line 320 for additional items to be placed here if the seller says, hey, you can tell the consumer XYZ. Maybe that's a moving date, or you have a need to stay in the house, post occupancy, something along those lines. Now, B is going to come straight from another form that we have. This is the RF301, working with real estate agent. This is a unilateral form that is available in the forms library. But that section right here for B talks about the duties owed to all parties of the transaction, regardless of being represented or not. So I like to say this is when you're working with people. So all customers get these 7 items, okay? This is kind of like your old car from pre-licensing. But then this one right here, the duties owed to a client, this is when you're working for somebody. So we're working with people, we're working for people. When you sign an agency relationship, whether that be a listing agreement or a buyer-broker agreement, that's when these 3 items come in. So if the two, either a listing agreement or buyer-broker agreement signed, then these 3 items get added on, and the agent must now abide by these duties. Now, here's where the appointed agent gets listed. This is going to be the agent who's representing the property. If they are on a team, their team leader is often listed here too, or if they're doing a partnership where there's going to be 2 agents from the office working on this, sometimes that happens. Both of the designated agents are going to be listed here. And remember, it's with the exclusion of all the other agents in the office. Okay, if the agents listed on this line here have something that happens, maybe they get hospitalized, or they pass away, or they're not doing a good job and you just don't want to work with that agent anymore, Number 2 talks about the appointment of the subsequent designated agent. The broker has the right at that time to go ahead and appoint another licensee. Now, number 3 is the default to facilitator status in the event both parties are represented by the same designated agent. So previously in this agency section, I walked you through facilitator, but also dual agency. Well, what happens when you are the listing agent, but you also have a signed agreement with the buyer? Okay, in the event, you would be a dual agent, but you have the option to also default to facilitator, meaning you're just kind of the paper passer again. If the offer doesn't go through, then you automatically will resort back to whatever agency status you were in prior to. So this paragraph right here just states that the designated agent shall default to facilitator status for all showings involving the same agent who's representing the seller and a prospective buyer. Okay, immediately notifying verbally the buyer and the seller of the need to default to facilitator status. And then upon any default to facilitator status, the former designated agent must assume a neutral position and shall not be an advocate for either the seller or prospective buyers. So if you have the listing and you have the buyer and the buyer's like, I want to see that house. And you're like, hey, heads up, just so you know, I'm the listing agent on that property and I represent the seller. When you get ready to go show the buyer the property, you automatically default to facilitator in that moment. And you immediately tell everybody what's going to happen. And then the buyer sees the house, and should they want to offer on the property, at that point, that's when you're going to go ahead and do your notification of change in status, which is the RF103. Now, if this deal doesn't go through, the offer doesn't go through, or even if it goes through and it falls apart later, number 4 says that you're going to have a resumption of the agency status that you were previously in. So the deal falls apart. Buyer then will go back into being represented exclusively as with the buyer's agent, and then you will also go back exclusively representing the seller. Now, I have a whole section on that piece, so check out the other videos for that one. Now let's talk about this earnest money. Earnest money is held by the broker. It is often held at the title or attorney office as well. It can be held at any designated place here in Tennessee, but it is designated and it's noted on the offer agreement. But the broker is authorized to accept the deposit from the buyer and then hold it. And there's different ways that the money gets dispersed. And so check out the video on the RF101 and I talk about disbursements. But with the earnest money, sometimes sellers like, hey, if they deposit that money, I get that money. And I'm like, no, that's not how this works. Earnest money is held in escrow. It's held until closing or until the brokers, have to dispute and say who's going to get the funds, or if there's a mutual understanding that the funds get dispersed. So just know that earnest money here in Tennessee is not a due diligence money. Some states have a due diligence period where the buyer pays the seller to keep the property off market during the due diligence. We do not have that here in Tennessee. This earnest money, also known as trust money, is held in escrow until closing unless otherwise needed to be released prior to closing. And when it goes to closing, it goes as a credit to the buyer. All right, let's talk about title. As a seller, the seller is responsible to transfer the property in what we call good marketable title. You can't have any liens or anything cuckoo crazy on your title. So just make sure that everything is good and cleared up. And if you know of any liens or encumbrances that are on the title, we, the agents, need to know that ahead of time so we can go ahead and notify title and try to clear those things up ahead of time. 15 talks about your home protection plan. If you want to provide a home protection plan ahead of time, you can. Your agent will provide you with some options that are, in the local marketplace of what the buyers typically request. And so you can offer that ahead of time. Most home warranty plans also offer a seller listing period program that's no cost to you to begin. So if you list your property, you can have the home protection plan in motion during the entire listing period, and then it's paid for at closing and initiates to the buyer at closing. So this is just a really great way for you to protect your property during that listing period, because we all know the sign goes in the yard and shortly after that, something breaks. So talk to your agent about having a home warranty plan, but should you not want to have a home warranty plan, you can check waived. Then you move on. All right, 16 is going to go into all the legal terms. I'm not going to go through all of this with you. You can read it here on the screen, but I do want to hyper focus here on section C, which is terminology. The days in our Tennessee contract are going to be calendar days. They end at 11:59 at the local time, unless otherwise specified in the agreement. And local time is determined by the location of property, because here in Tennessee, our state is in Eastern and Central time, depending on where you're at in the state. So calendar days, 11:59, local time, and local time is where the property is located. Okay, we do have a fair housing block in here that all agents are responsible to abide by fair housing laws, and those are all listed down here, which areas are protected. And in Tennessee, we also have the protection of creed. Okay, so we have the federally protected classes, and then in Tennessee, we also have the protection for creed. Additionally, you're going to have more legal information listed here, but there's that line 320 that I previously mentioned regarding confidentiality. If the seller authorizes you to disclose something, you can, and it would be placed here. Otherwise, we zip it. Don't start disclosing things you shouldn't be disclosing. You'll get yourself in trouble as an agent. Exhibits and addenda are the next section. These are found on the 500 or the 600 series. So if it starts with 5 or 6 in your formed library, they can get listed here. And then we're on our special stipulations block. Now, as an agent, do not become Shakespeare and start writing all sorts of legal things here. You are not an attorney, and therefore you shall not write legal verbiage here without approval first. Check with your broker. Oftentimes, the broker are going to have office clauses that you can utilize that were already predetermined and pre-approved by the broker and the legal staff. But the biggest thing here is you can click, when you're in transaction desk, you can click this block. There's a blue block that appears in your forms library. And when you click it, it's going to have an add clause button. When you click the add clause button, it's going to give you personal, office, or system clauses. The system clauses are pre-written, and you can find those clauses on the RF707. But they've taken everything that's a RF707, which is your additional contract language, and they've placed them into transaction desk for you as system clauses. But previously, we were discussing the cooperative compensation. And so this block right here would be, where you would see on the offer side in their special stipulations where they would ask for it. So if in the listing on this document, you put 0 for cooperative compensation, just know there's a special stipulation block like this on the RF101, which is your purchase and sale agreement. And that's where the buyer broker will negotiate for the compensation at that time. So you have options. This stipulation block for the listing side is going to be where you're going to add things in like the cancellation fee. I don't want you to put a sign in my yard. I don't want the lockbox left outside. I'm going to bring it inside. I want so-and-so to do so many open houses. Whatever is negotiated, it all goes here. So it's all in writing between the seller and the listing broker. Now here's where everybody's going to sign. If you need additional blocks, you're going to go ahead and add those additional blocks with the RF715. It's a whole page just for signatures. So you're not going to put 2 signatures side by side here to try to squeeze in more than 2 signatures. No. Use the 715. It is a whole sheet that gets attached to. Now, if you're going to be co-listing an agreement between 2 firms, that's the RF111. This one simply says, hey, we're going to go ahead and have 2 firms listing this property, and you're going to have the primary firm fill out the 101, the one we just reviewed, and they're going to fill this one out to say there's a co-listing broker and what happens with the co-listing broker's compensation. All right, that's it. My next video is going to be on the RF141, where we're going to dive into the exclusive buyer's rep. So if you like this video, hit subscribe. Check me out every week. There's going to be a new video covering the Tennessee REALTORS forms. Look forward to seeing you on the next one.